Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Welcome to SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Federal Society's Faculty Division. On June 23rd, the Supreme Court decided New York State Rifle and Pistol Association, Inc. v. Bruen. In a 6-3 decision, the court struck down New York's handgun licensing law that required New Yorkers to demonstrate a proper cause in order to be granted a license to carry a pistol or revolver in public. Justice Thomas delivered the opinion of the court in the first major case on firearms regulation that the court has considered in over a decade. Joining us today to discuss this decision and its implications is Professor Mark W. Smith, a visiting fellow in pharmaceutical public policy and law in the Department of Pharmacology at the University of Oxford, presidential scholar and senior fellow in law and public policy at the King's College, and distinguished scholar and senior fellow of law and public policy at Ave Maria School of Law.
This is a major decision. This is the first huge decision involving the Second Amendment in over a decade, and it was much watched because, as you know, the text of the Second Amendment talks really about two rights. There's the right of the people to keep arms, which was addressed in the cases of Heller and McDonald, meaning you had the right to possess them loaded in the home, unlocked, ready for confrontation and self-defense. But Heller and McDonald did not directly address what the meaning of that second textual right was, the right to bear arms. So today in NYSERPA versus Bruen, the Supreme Court talked about what does it mean, what does the text mean of the right to bear arms in the Second Amendment? And what the court found, which was widely understood they would likely do, is that indeed the right to bear arms, just like the right to keep arms, protects a fundamental individual right. In this case, the right to bear arms means you have a right to carry a loaded handgun unlocked outside in public in anticipation of self-defense or other confrontation to protect your life or the lives of others. Now, before I get into sort of what I think are the significance of the legal rulings, and there's a lot of major ones, especially if you're interested in originalism, the one thing I will say about NYSERPA versus Bruen is this is a huge, momentous victory for originalism, which we will get to in a second, about how they analyzed the text of the Second Amendment as well as the history relating to the Second Amendment. And Judge Barrett's concurrence actually touches on this in some detail, which is quite interesting. So to begin with, for those of you who may not be entirely familiar with firearms law in the United States, generally speaking, there are 3 types of laws in the United States right now that allow you to carry guns outside the home for self-defense. The first type of law is called permitless carry, which basically metaphorically says, well, the Second Amendment is your gun permit. You're allowed to carry a gun outside the home for self-defense. You don't need any government permission or license to do so. That's called permitless carry. That is the law in 25 states right now have permitless carry regimes that basically, if you're a law-abiding American, you're an adult, you are not a prohibited person under 18 U.S.C. 922G, you are allowed to carry a gun outside the home for self-defense or lawful purposes. The second regime is called shall issue. Now, what shall issue is, it's short term for saying that a state sets forth a criteria, an objective criteria that law-abiding Americans can readily meet with some reasonable steps. So a shall issue carry regime says that as long as you, the American citizen, meet an objective criteria of, let's say, you're an adult, you have basic training, you have gone through a background check, you are not a prohibited person under federal law to touch a firearm, then the government authority mandatorily shall issue a carry permit for you to be able to carry a handgun outside the home for self-defense purposes. Now, right now, there are 43 states that are either shall issue or permitless carry or some combination of the two. So this gives rise to the specific issue of NYSERPA versus Bruen, which touches on the third type of carry regime in the United States. And this is called a may issue regime. And may issue turns the Second Amendment into a privilege, meaning you, the American citizen, have to go to a government official, usually a law enforcement department like the like the state police or a local police department, and you have to ask permission of that state government authority for you to be able to exercise your right to carry a gun. And in order for you to meet the criteria or of being allowed to carry the gun, it's not objective. It's up to the government deciding that you are exceptional, that you are special in some way, that you have a special need to carry a firearm, as opposed to being just an American worried about self-defense. So this may issue regime was what was challenged today in NYSERPA versus Bruen, and the Supreme Court held that the Constitution doesn't work that way. You, as an American, have the right to carry a gun outside the home for self-defense. It is your right. You do not have to go mother may I to a licensing regime and ask for permission and beg them to get that special license. And that's what happened in this case. The facts of this case were quite simple. There were several gentlemen in the state of New York. They went to their local law enforcement. They said, we're worried about using a gun we want to have a gun for self-defense. And they said, do you have a special need? Are you unique? Is there something special about your situation? They said, no, we're just Americans. We want to be able to carry a gun for self-defense generally. And they said, that's not enough. We're not going to give you the permit to carry statewide a handgun. So that, of course, caused a lawsuit that went up. The district court held against the Second Amendment in favor of the government. The Second Circuit Court of Appeals affirmed that, saying that, yeah, may issue permit regimes are constitutional. And then, of course, cert was granted. And today, the question presented in the case was, can a government agency or can the government prohibit ordinary individuals from carrying handguns outside their home for self-defense, which is what these may issue regimes really were doing. And of course, the Supreme Court today said, no, the government cannot do that. You have a right to carry a gun outside the home for self-defense under the Second Amendment's right to keep and bear arms. So that's sort of the background there. Now, the other major thing, in addition to the fact that the plaintiffs won, is what are the 6 states that are these may issues? And this is quite interesting. As I mentioned, there's 43 or 44, depending on how you define it, states that basically allow you to carry a gun if you meet objective criteria or if you're just a law-abiding American. We were really, in this case, only talking about outlier jurisdictions. This was a distinct minority of states, which consisted of New York, New Jersey, California, Maryland, Massachusetts, and Hawaii. Those 6 states were really outlier jurisdictions. So the Supreme Court in this ruling today really said, look, you 6 states, specifically New York in this case, said you have to bring your state laws allowing people to carry guns away from the may issue regime and bring it more into line of either a permitless carry or a shall issue regime. And they specifically said, by the way, that shall issue regimes are perfectly constitutional. That was a point made by Justice Roberts and Justice Kavanaugh in a concurrence where they said that, nothing's wrong with shall issue regimes as long as they're objective. So that's, I think, what, states like New York are going to have to move to. Now, the next thing to consider is the standard of review. And this is a very big deal. In some ways, this is the most important part of this case. The standard of review involving the Second Amendment has been going back and forth for the last 10 years. And what's gone on is those decisions that I would say are more favorable to a broad interpretation of the Second Amendment have applied a standard of review called text, history, and tradition. Text, history, and tradition, where you look at the text of the Constitution of the Second Amendment first, and then if there's any ambiguity or questions about what it meant, you then look at history and tradition. That's on the one side. But what we found is usually on the gun controller side, the people that wanted more robust gun controls and gun restrictions, they didn't like the text, history, and tradition test because at the time of the founding, there were very limited restrictions on firearms. Arguably, they were limited to like some fire-related restrictions involving that you couldn't have black powder in certain wooden structures, like in the city of Boston, because if the black powder which you used to fire a firearm back then caught fire, you ran the risk of burning down entire cities that were predominantly made of wood. So sort of if you want to call them the gun prohibitionists or the gun control lawyers, or in this case, the state of New York, they didn't like the text, history, and tradition standard of review. They preferred a different standard. And over the last 10 years, they developed what's been known as the two-part test standard of review, a two-part test. And the two-part test they came up with, step one, does a particular gun control, gun statute, gun regulation touch upon the Second Amendment in some way? And when they did that first prong of the test, they did look at the text of the Second Amendment and the history and tradition. And if they found a particular gun restriction touched on the Second Amendment, they then said, okay, it involves the Second Amendment. Now what? And this is where the New York State was encouraging the court to go. They then said, we're going to have a second step of really a balancing test, a form of tiers of scrutiny. Now, for those of you who aren't familiar with this, tiers of scrutiny from law school is effectively a balancing test where you balance the interest of the individual whose individual rights are being violated by a law or restricted by a law against sort of the public welfare. That's a very simple way of talking about tiers of scrutiny. Historically, over the last 10 years, the courts that have been, by and large, upheld gun control laws have applied intermediate scrutiny. So again, the courts that have basically embraced gun control and upheld them have said, yes, step one, if it violates the Second Amendment or infringes on the Second Amendment or touches on the Second Amendment, that's step one. But then we go to step two and engage in really a social science or statistical analysis of, is the gun control law good for public safety relative to the violation of the individual rights? And inevitably what happened in virtually every one of these cases at the end of the day, the courts defer to the findings of the legislature and they upheld the gun control statute. Now, this court in NYSERPA versus Bruen made clear, very clear, that standard review that the state of New York and other states that generally like gun control, that this is not allowed anymore. The court was very clear that going forward, the only issue as to whether or not a law violates the Second Amendment is prong one, step one, which is, does this impact or infringe upon the text or the history of the Second Amendment? If yes, that's game over. It is a violation of the Second Amendment. It cannot stand. That law cannot be enforced. Period, full stop. That's what this opinion says. So that second part, which was always being used by courts to uphold legislative findings that gun control somehow save lives, that was the argument. And the court specifically says that lower courts may no longer do that again, that they may not engage in this kind of analysis. In fact, I'm going to quote what Clarence Thomas said today. He said in the opinion, if the last decade of Second Amendment litigation has taught this court anything, it is that federal courts tasked with making such difficult empirical judgments regarding firearms regulations under the banner of intermediate scrutiny often defer to the determination of legislatures. But, and here's the key language from Justice Thomas, but it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it is this balance struck by the traditions of the American people that demands our unqualified deference. So that was unequivocally clear that the court is no longer going to allow lower courts to engage in interest balancing. Now, I want to mention the ruling here. It's worth noting that this was a 6-3 decision on the opinion by Clarence Thomas. And this involves, of course, Justice Roberts signing off as well. Although there's some concurrences I will get to in a few minutes, it was a 6-3 decision on the merits of the matter and the robust opinion that rejected this tiers of scrutiny. So the standard review going forward is really text and history, very much an originalist notion along the lines of what Justice Scalia wrote in Heller and Justice Alito wrote in McDonald. So yes, that's the standard review. Now, the other interesting holding before I get to the concurrences in the dissent is common use or typically owned. One of the next cases coming up, I am guessing, is whether or not AR-15, quote unquote, assault weapons can be banned under the Second Amendment, and a derivative case involving so-called large capacity magazines, which are really standard capacity magazines that legislatures around the country just label as large capacity. Now, there are multiple cases pending before the Supreme Court right now up for cert. Whether or not the Supreme Court's going to GVR, grant, vacate, and reverse those cases or take one of them, we don't know. But what's very telling is this. In this decision by the Supreme Court in Bruen today, they reaffirm, again, in the 6-3, they reaffirm in the 6-3 the common use test. Now, what the common use test is what arms, right, the right of the people to keep and bear arms shall not be infringed. So what arms are protected by the Second Amendment? Well, we know that arms are anything that can be used defensively or offensively, to protect a person. And the Supreme Court in Heller and in McDonald and in Caetano, which dealt with stun guns, and today in Bruen reaffirmed the following test, which is if a firearm or a weapon is commonly possessed by Americans for lawful purposes, it is a protected arms under the Second Amendment. Now, this is significant because we know that AR-15s and so-called large capacity magazines are owned in the tens of millions, if not hundreds of millions when it comes to magazines by Americans today. So that seems to be, although they specifically say we're not dealing with other Second Amendment issues today, the fact that the Supreme Court reiterated the common use or common possession test for arms that are protected seems to suggest that would bode favorably for those that are interested in striking down laws involving large capacity magazine bans or AR-15 style assault weapon bans. But again, we don't know that, but that is, I think, a tell from the Supreme Court on the types of weapons. The next critical thing, and this is something that everyone who followed NYSERPA versus Bruen was very interested in, was the notion of sensitive places or gun-free zones. In the Heller decision, and this has now come out over the years through, I think Justice Stevens wrote his memoirs about this. In the Heller decision, there was the urging, at least according to reports that I've read, that Justice Stevens, who was in the dissent in Heller, encouraged Justice Kennedy to write a small, short section in Heller that basically said, yeah, we know we're deciding Heller, this is you have a right to a loaded firearm in your home for self-defense purposes, but this decision should not be taken as evidence or proof or something that a lot of the longstanding gun control laws in America are problematic or unconstitutional. One of that involves banning guns in quote unquote sensitive places. Now, sensitive places is the language that was used by the Supreme Court in Heller. And again, it is a euphemism for gun-free zones, saying the government get to ban guns in a school, we get to ban guns in a polling place, whatever it is, wherever they want to label it. So one of the concerns, or depends on the side of the case you were on, was would the Supreme Court try to address the notion of sensitive places and either expand upon it, reaffirm it, or narrow it from the language they used in Heller? Because in Heller, they said that nothing about this decision suggests that, laws banning guns in sensitive places such as government buildings or in schools should be a problem. They presumptively said those laws would be constitutional. And what's interesting is in the briefing in this case, there was a lot of sort of flagging of the issue that said, geez, Supreme Court, if you issue a ruling that says New Yorkers have a right to carry handguns outside the home under the Second Amendment, what's to stop the state of New York or from any of these states that generally are unfavorable to gun rights? What is to stop them from basically saying that the entire state or the entire city is a quote unquote sensitive place? Can't they just pass a law that says, everything is a sensitive place if they serve alcohol, if there's more than 5 people in it, if there's lights on, if anything, right? You can define it, you can label anything you want. And there was concern that if the Supreme Court did not say something about sensitive places, then what would be the next step by states like New York would be to pass law saying essentially the state is a sensitive place. And the Supreme Court actually did address sensitive places in this decision. And what the Supreme Court said is quite interesting. They acknowledged this notion of sensitive places, but they said that you address this historically, meaning you go back in time to the founding era and ask yourself, were there sensitive places based on the history of America that you could not bring firearms? And although they didn't squarely decide sensitive places, they alluded or mentioned some things that could be sensitive places or gun-free zone. They specifically mentioned in their opinion polling places, They mentioned legislative bodies. Legislators could be the Capitol, U.S. Capitol, state Capitol, and they mentioned polling places, state Capitol, and courts. So what's interesting about that list of sensitive places in today's opinion is they all, and then they do reference the Heller quote involving schools. So if you look at that, all four categories, assuming you talk about public schools at least, touch on a government function. So one could read this decision as suggesting that the only gun-free zones that would pass constitutional muster as a sensitive place would be those areas where there's some sort of government activity taking place, whether it be voting, legislative acts, a court decision. The other interesting note I would suggest is that those are also places that are treated as sensitive places in that they have people there with firearms to protect you. So if you go to a government building, you go through a metal detector, and then there's people there with firearms to basically take the burden of protecting yourself off your back and put it onto the back or the obligation of the government. Again, that was a big question. The Supreme Court did deal with sensitive places. The way they did it seems to have narrowed the definition from what they were saying in Heller to those places where you have government-related activities. The last thing I want to mention is just the dissent and the concurrences. So there was a dissent. The three justices, Justice Breyer with Justice Kagan and Sotomayor, Justice Breyer wrote the dissent. And I would summarize the dissent really as saying that because guns kill so many people, of course, guns don't kill anyone. People using guns kill people, but set that issue aside. They essentially said because of the serious consequences of using firearms in their view are so deadly and problematic for society, we feel the need that we can treat the Second Amendment differently from all the other rights. And in the concurrences, Justice Alito specifically wrote a very detailed concurrence where he goes almost line by line and really addresses all the specific arguments made by the dissent. So that's really what the Alito concurrence was. So Alito, I should note, says, I subscribe and embrace the court's decision in all respects. So this was not like a plurality or anything like that. He says, but in addition, I want to address specifically some of the arguments made by Justice Breyer's dissent, and that's what he does. And again, what's interesting also is that Justice Kavanaugh writes a concurrence as well, and Justice Roberts signs on with that, and he makes essentially one critical point to say that there's nothing unconstitutional in Justice Kavanaugh's view about shall issue regimes. Again, as I said at the start, 3 types of carry regimes for handguns in America: permitless carry, shall issue, and may issue. This case struck down may issue statutes, but embraced shall issue or permitless carry. And Justice Kavanaugh, probably to head off at the pass any suggestion that a shall issue permitting system would be unconstitutional, he and Justice Roberts say nothing about a shall issue regime, if done objectively and rationally, is a constitutional problem. And that was the essence of his concurrence. And Justice Barrett, she made very clear right from the start, as did every concurrence, that she embraced completely in full the court's majority 6-3 opinion, but she did want to add one point. She simply said that there was a discussion at oral argument, that there was a discussion that's been going on about which is the relevant time period for history, because again, the standard of text, history, and tradition, what is the history? When does the history begin for you to consider as a court? When does the history end for you to stop considering it? And she simply said that we, involving the Second Amendment, as she saw it, did not resolve whether the relevant time period for Second Amendment cases is at the time of the founding, 1791, when the Second Amendment is adopted, or is it the founding era then, or should it be post-Civil War, post-14th Amendment ratification time period in the late 19th century? She said, we haven't clearly resolved that, but in her view, we didn't need to resolve that in this case, because either way, the right to carry guns outside the home was clear based on history, in whether you look at the founding era or the post-Civil War era. So Justice Barrett just flagged this as a future issue to be considered, but didn't really take an official position on it, because she said you didn't need to resolve this case in favor of those that were looking for an expansion of the Second Amendment right. Okay, so I think those are the highlights of the decision. There's a lot more to talk about, but I think that gives you a sense of what the case was about and the decisions that were rendered.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.